In today's video, we return to one of my favorite subjects, common labeling mistakes that dietary supplement manufacturers and distributors make when creating marketing claims for their products. Hi, I'm Michael H. Cohen, founding attorney of Cohen Healthcare Law Group. We help healthcare industry clients navigate healthcare and FDA legal issues so you can launch or continue to scale your health and wellness product or service. This is one in a series of videos, so we'll pick up the thread with criterion 4 used by FDA to determine whether a dietary supplement manufacturer or distributor has made a disease claim. FDA says, criterion 4, it is an implied disease claim because of the product name, formulation, use of pictures, or other factors. Okay, that's criterion 4, and there are a couple of principles here that this breaks down into. So first, the product name itself can make claims, makes claims. For example, the product name contains the name of a recognizable disease, such as coronavirus, diabetes. Or the product name includes words such as cure, treat, prevent, or even correct. As all of that suggests disease care, it thus is not part of an allowable structure function claim. Second, the company can make claims about product formulation, but those claims can create disease claims. For example, if the product contains an ingredient that FDA regulates, primarily as a drug, that itself can cause FDA to classify the product as a drug. Third, our claims using citations the company makes of publication titles. So, for example, if the dietary supplement manufacturer or distributor, and remember, that distributor can be a medical doctor, a chiropractor, another practitioner, a nurse, if that person or company cites a publication and that publication cites a disease like cancer, diabetes, arthritis, virus, FDA might say that you've got a drug claim. Of course, there are nuances because the FDA looks at labeling as a whole. And FDA also has a trump card in that it can use any statements as evidence of intended use. So FDA always has enforcement discretion. The fourth part of this criterion 4, it's obvious the product marketing claims use the term disease or diseased. There's a carve out here as well. FDA says you can make general statements about health promotion and disease prevention as long as the statement doesn't imply that your product can diagnose, cure, mitigate, treat, or prevent a disease. The fifth subcategory, the use of pictures or symbols that imply disease. FDA again draws a boundary between permissible and impermissible uses here of pictures and symbols. For example, pictures of healthy organs would constitute an appropriate structure function claim, while a picture of an abnormal tissue organ would be an implied disease claim. As with other implied claims, it's the overall context, the total claim, that's important. FDA notes that there are some symbols like the heart symbol we mentioned that are so widely recognized as symbols for disease treatment and prevention that their use is ordinarily an implied disease claim. And a similar example would be, for example, EKG tracing. And FDA also says that the symbol RX can be misleading, so watch out for that one with supplements. If you'd like an early read, let us know. We offer a legal strategy session with a member of our legal team. That's a paid consult. And if you'd simply like to know more, click on the link below, cohenhealthcarelaw.com/contact to send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to working with you soon.